Hello, my name is Pia Trigiani, and I am participating in a project of the Virginia State Bar Real Estate Section in partnership with the Virginia Law Foundation, where a number of us who have been practicing in the real estate area of the law have been asked to talk about our practices. My practice is in representing common interest community associations, although it didn't start out that way. I came to the practice in 1982-83, even while I was in law school at the University of Richmond Law School. While in school, I needed a job, so I started working for the Virginia Real Estate Commission, which later became the Virginia Real Estate Board. The Real Estate Commission was responsible for regulating the sale of residential condominiums in Virginia. Also had as part of its regulatory program the regulation of real estate timesharing and the regulation of subdivided land, which was a holdover from 1978 when there were a lot of land sales fraud, particularly coming out of Florida. But the program then, I started as a young intern working under the direction of members of the Virginia Attorney General's office who were embedded in the agency, and we reviewed the applications for registration. After law school, I stayed on with the agency, and it was a great experience because eventually I became the director of the program. I was called the condominium administrator, later called the property registration administrator. That was in the 80s. Jobs were different then. The job market for lawyers was challenging. I always thought I was going to go home to Southwest Virginia and be a litigator, a trial lawyer, but my career path took a big veered a little bit off of that and veered into this real estate-based practice. I worked at the agency for 4.5 years. I was responsible for all of the regulatory development. We conducted a number of studies during that time about whether or not to regulate not subdivided land sales, but change it to look at property owners associations. The repeated recommendation after a couple of studies was no, that's not a regulatory program that makes sense, that the condominium regulatory program came out of a different time and a different need. In the late 80s, I was asked to join a firm in Northern Virginia, which was a good thing because I never interviewed for the job. As I like to tell people, I barely got into law school and I barely got out. And angels sometimes, unknown to you, steer your path. And that was another one of those pivots in my career. I went to Northern Virginia and went from the white hat regulator to working with regulatory official, working with the developers. I joined a firm, a large firm that was just had gone through a merger. In fact, my first day with the firm was merger day. And at that time, I took the, I was working with the person that I would call one of my 3 mentors. He taught me this practice, taught me the development side of it. I'm going to go back to my days at the Real Estate Board for a moment to say that while I was there, I was not in a lawyer capacity. I was more of a bureaucrat. Although the agency in which the Real Estate Board was housed, the Department of Professional and Occupational Regulation, which at the time was the Department of Commerce, its name changed too, was a very entrepreneurial, non-bureaucratic thinking regulatory program. So it was not a stifle development, it was disclose about the development. And I worked there with, had several mentors, but the one that I I credit with some of my perspective on working with people, which is what this practice is all about, was Richard Zorn. Richard Zorn, Dick Zorn to me, was in the Attorney General's office, and he was counsel to the Real Estate Board. And from him, I learned how to navigate and work with a board of directors and really learn from him about how to work within a regulatory scheme and work with citizens, a board of directors, which was at the time was the real estate board. So after I left state service, which I think was very formative to my way of looking at things, I went to work for a real estate development firm. And there I kind of learned the other side. And the other side, working with Robert Diamond, who I think is probably the best draftsman of these documents. And the reason is because he thinks through to operational issues. Bob is a mastermind at looking at what the law says and working with a developer to achieve the developer's goals, but at the same time keep in mind what the byproduct is, what the end product is, what the association needs to have in its documents in order to function and do all that needs doing for a community. You know, developers are creative people. They want to build neighborhoods. They're dreamers. They like to find ways to take what they learned and what they lived in their childhoods and recreate that. But they also have to be pragmatic about it and make sure it works. So this whole notion and idea of common interest communities is part of that. It's creating neighborhoods. But the important part of the neighborhoods, the neighborhood aspect, is in creating in that neighborhood documents that work and documents that make sense based on that development. The beauty of the Virginia law is that it's flexible. It was drafted by a gentleman named Steve Jonikin, who passed away, but he was brilliant. He worked for Virginia Land Title. He was a title guy, but he was brilliant, and he worked with William Griffith Thomas, Bill Thomas, and they drafted the Condominium Act in 1974. Virginia's law is the first second-generation statute across the country. It was the model, and later the model, for the Uniform Condominium Act and the Uniform Common Interest Ownership Act. And that was the brainchild of Steve and Bill. I worked with them. I had the benefit and the good fortune of working with Steve when he was practicing, both as a regulatory official and after. We practiced law together, as I did with Bob Diamond. They taught me that the law has different ways to look at it. There are different ways to look at it. Steve would come into my office and he'd say, "Pia, what do you think that says?" And I'd say to him, "Steve, you wrote it. What do you think it says?" But he was brilliant in the way that he knew that words have life. And Bob's the same way. When I started working with Bob, I learned that you really need to draw the information out of the developer, put it in paper, and I would love to watch him draft, because I would sit and he would listen to the client, and he'd ponder it for a minute, and then he'd write. I've never seen never saw anybody who could draft on the fly like he could and still can today. But I did not initially have that skill, but I learned it, and it's done me well in the path that my career has taken. So I went from regulatory official to developer, a lawyer, and then I met David Mercer. David and Bob were partners with Steve Jonikin, and David had chosen early on in his career, and by the way, I call them the first generation of community association lawyers, and they were learning at it. It was new. If you think about it, 1974, the Horizontal Property Act, which preceded it in 1962, it's a pretty narrow and new area of the law. But David had chosen early on, he didn't like the tedium of drafting. He was more of a talker. He was a litigator. He came out of and approached the law from the arguing perspective, the litigating side. And while he went to work with Bill Thomas, who wrote the Condominium Act with Steve, Bill had him read the Condominium Act. He tells this story, and it was right, he started working with him right when the act went into effect. So we worked on early documents. Bob refined those. Steve refined them. But David really liked the part at the back end. He liked representing the association, the byproduct of Bob's work, Steve's work, Bill's work. He liked representing the association at the end of the day. And so I started working both with Bob and David, and as it came to be, I liked the people side too, like David has liked and enjoyed. And I started doing more and more of the community association practice from the community association perspective. So my career has really been full circle. The circle closed in 2008 when I was asked by then Governor Tim Kaine to go on the Common Interest Community Board, which was created by the General Assembly in 2008 to take the place of the Real Estate Board and take responsibility for the registration programs, and to add another element to it, which was to regulate, to some extent, community associations. So I went back home. I went back to the department and was the lawyer representative on the Common Interest Community Board, and I was elected chair and served as chair from 2008 to 2011 when I was termed out of serving on that board. So I was there to help recreate the regulatory program for the common interest community area of the law. I worked with amazing staff of that agency who dug in, were the best regulatory draftsmen I've ever worked with, and we created out of whole cloth this new regulatory program. That's my career path. Now, what do? I represent community associations. Sometimes homeowners, sometimes unit owners, but mostly it's the association side. And that practice is a little bit of everything. I refer to it as the last bastion of the general practice of law. Well, what do you mean by that? I said, it's a little bit of everything. It is absolutely rooted and founded in real estate, covenants, restrictions, easements, recorded documents, title, proffers. It really is the development of a community association, and what the community association lawyer who represents associations has to know is all of that. That's why I think my path has made me better at this practice, because I've done it all. I've drafted for developers. I've regulated developers. I've done a little bit of all of it, and that has helped me understand. And probably because some of us come at the law differently. I'm not a natural lawyer. I'm more of a teacher. And to be honest with you, that's a good aspect and a big aspect of this practice, is the teaching aspect of it. But the practice really, as I said, is the last bastion of the general practice of law. It involves contract law, one of my worst grades in law school. Real property, I did okay. Corporate law, I really did well, particularly because I didn't even buy the book, which I'm very proud of to this day, as you can tell. And there isn't any criminal, well, there can be, there have been on occasion, but contracts, litigation, bankruptcy, collections, zoning, it really is environmental. It's really a cross-section of all of the practice areas. There's no day where I do the same thing every day. That's what makes it interesting, and what makes it even more interesting are the people. But in terms of the practice, yes, you must know the Condominium Act. And as one of my early colleagues said to me when I'd go in and ask him a question, Pia, have you read the statute? It's in there. It's like the spaghetti sauce. It's in there. That's true in the Condominium Act because condominiums are creatures of statute like corporations. Think of it that way. Property owners associations are like partnerships. They're common law. So the Condominium Act is the recipe, the cookbook, how you create, how you manage, how you live in and operate a condominium. The Property Owners Association Act, enacted in 1989 over the objection of a number of us who really wanted the General Assembly to adopt the common interest community law that had been recommended by the Commission on Uniform State Laws, is much less. It started out as a resale disclosure to a purchaser. This is what you're buying. Danger, Will Robinson. You're going to move into a community that has another layer of government. You got to pay assessments, taxes. You have to abide by the rules. There's rule enforcement. That's what the Property Owners Association Act was originally designed to do. We were there when it was enacted, and I call it David Mercer's Khrushchev moment in 1988 when he went to the General Assembly and took his shoe off and basically banged it on the table and said, "You can't adopt this thing. You can't enact this thing." Well, they ended up doing it 1 year later, but over the objections of a number of us. But it's something that's been modified and amended every year since its enactment. So when we look at problems, when we look at issues, when our clients present us with questions, we go first to the documents, but we also go to the law. I would say, and what I describe to volunteer leaders who lead these communities, your documents are another level of the law. You've got to understand them, work within them, and the courts are telling us more and more as these cases develop that you are limited. You must follow what the documents require of you. That's your first stop, not your second, your first. So that's what we have learned in the practice as it's developed. But having a strong understanding of the Condominium Act, the Property Owners Association Act, and the Virginia Nonstock Corporation Act, because most of these associations that are well, let me say it this way. Condominiums in Virginia do not need to be incorporated. The association, the statute gives you all of the foundational creation protections that you get by incorporating. So our typical recommendation is don't incorporate the Condominium Unit Owners Association. But on the Property Owners Association side, you must be incorporated because unlike the condominium form of ownership, in a Property Owners Association, the association owns the common area. And you have to have a legally viable entity that's protected from liability. And that early on in the development of these community associations, it was determined that the Nonstock Act was the best way to do that. Although there is a growing trend with not incorporating, but creating these associations as limited liability companies. It's a little bit contorted in my mind, and some of that may be because I'm used to the Nonstock Corporation Act, but the difference is that the managing member in a limited liability company has more authority, so that the general manager or the manager of the community can have additional authority. So in preparing as a lawyer to be a great community association lawyer, not only do you need to understand those statutes, have a good ability to work with, interpret, understand documents, but you also need to be familiar with other areas of the law. We review a lot of contracts for clients, large and small. We review leases. We give comment on corporate resolutions. Every association has 5 or 6 founding resolutions establishing due process procedures, processes for access to books and records, assessment collection processes and procedures, committee charters, Those fundamental resolutions are corporate, and they come on the corporate side. We work with our clients to develop those and guide them through the not only the drafting, but the development and the implementation of them. I would tell you that the practice is a little bit of being a town attorney and a lot of being an in-house or general counsel to a corporate entity. Some of these associations are big. Virginia has one of the largest, Reston. Reston Association is 10,000 homes, I think 50,000 residents, but it is a property owners association. Not many people know that. They've considered incorporating over the years, but it's 10,000 homes. That's 2.5 or 3 times the size of my hometown in Virginia. That's big. So they face, as do many associations, and there are other large ones there that are in Loudoun County and Prince William County. They have and face the same issues that towns, cities have, and they too, like towns and cities, are limited by their charter, the documents. That's the best analogy I can give it. Over the years, one of the more rewarding parts of my practice has been the interfacing with the volunteers. Well-meaning people many times, sometimes not. It's politics with a little p, so you get different folks elected. It's a corporate board, a corporate-like board, but they are also elected. But when they come on those boards, one of the things that we encourage them to understand is that they're fiduciaries, that they owe their obligation not to those who elected them, but to that corporate entity, who, by the way, is our client. The board is not our client. The management company that serves the community like we do is not our client. It's the association. It's that invisible entity. And we dispense our advice in the best interest of that entity. We work with the board. We work with management. We're a team. We're collaborative. But at the end of the day, sometimes we have to deliver a message that the politically elected volunteers may not like. And there's a risk. The risk is you lose the client because they make the decision on who the lawyer is. But I will tell you that sometimes you have to back away. You have to withdraw from representation. I've done it. I don't like doing it, but if I have to, I must, and I will. But we always have to act and think as the lawyer for the association in the best interest of that association. So a very important component for these volunteer-led communities is working with those volunteers to understand the documents, to understand their role and their responsibilities, balanced against the role and responsibilities of individual homeowners, owners. Sometimes these are commercial, by the way. They're not all residential. So that they can do their best. They can do the service that they need to do on behalf of the community. An aspect of that in the training has been working through trade associations and in other places offering through the we actually offer through the City of Alexandria quarterly programming. We ourselves offer programming for our clients that teaches them on the various aspects, teaches them about the various aspects of what we do and what they do. We've also been committed to the legislative process. Growing up as I did and working with Bill Thomas and Steve Jonikin, Bob Diamond, David Mercer, I knew the importance of the legislative process. And quite honestly, it's what I liked when I was a state official. During my time at the Real Estate Board in the 80s, I testified a lot at the General Assembly. My opinion was requested and asked, is this a good change? Should we make this change? What's the better approach? As all state officials are asked. So I was bitten by the bug early on, and I went to work with the guys who did it, who made the law, who who created it out of whole cloth and really, are the reason we have the strong reputation and the consistent reputation we have in the law in Virginia. So I've stayed involved, and over the years worked with various organizations to support legislation, oppose legislation. And what I would tell you in reflecting on my practice has been my prouder moments is having a hand in the structuring of the law. I may not be qualified as first generation in this practice, and would never assume or presume to be. But I learned from those guys, and what I learned was the G and Haw and of working with people, and also how to think creatively to fix problems, to find ways to not just say, no, you cannot do that. Here's what you can do, but here are the risks. Is it a good idea? Is it a bad idea? Here's the solution, but there are risks with taking that path. And so I like to think and hope to think that at the end of the day, the contributions that we've made have been to improve the law, make it workable, have it make sense, be even-handed about it, protect homeowners from crazy wackadoodle boards, and there's some out there, and likewise protect those boards from the crazy wackadoodle homeowners. They're out there too. Look, community associations and living in a community association is a bit of a social experiment. One of the things I've had the fortune of doing is serving on a college board of visitors for one of our state universities. And what I learned from the president of that university was the value of a residential college, that living with each other is what we need to be better, that part of the college experience is that dorm life and learning to live with people who aren't like you. And I don't mean, the obvious things, how we're different, but the other ways we're different. How you put the toothpaste tube back on, how you, or don't, how you roll the toothpaste tube to get the toothpaste out, whether you get halfway through and you throw the tube out and you get a new one. There are lots of different approaches, and what I've learned from that first generation was how to guide the people that are different to find commonality and to work towards the goal, which is to create a neighborhood, to add value to your home, which is your biggest investment, and how to make sure that you have a workable, cordial neighborhood. It's been a great practice. I think if you're interested in working with people, working in a semi-political environment, corporate in nature, and you're ready for the challenge of learning an area of the law that's somewhat unique, but also is a crossroads, a cross-section of all other areas of the law, this is a great practice. In reflecting on it, I would tell you I've enjoyed it. It's been interesting. It's been rewarding to be on the front end of the practice. I do believe there are challenges. I don't like change. I'm a true Virginian that way, but we have changes coming. We're living in a pretty disruptive society right now, and that is reflected in community associations. So we need to be the steady ones. We need to steady the course, keep people on track, help them understand they're limited by what their documents and the law tells them, but there are ways to meet their goals and serve their community. It's been a great opportunity to have a chance to tell you a little bit about my practice. I am very grateful to the Virginia State Bar, Real Property Section, and our little Common Interest Community Association Committee for asking me to be one of the people featured in this series. But I would tell you, at the end of the day, and looking at your practice, don't just do the day-to-day law. Reach around it, reach behind it, reach in front of it, get involved, be a change agent, and enjoy it. Learn from it. Be a lifelong learner. And I thank you again. Thanks for listening to me prattle on. But glad always to talk to folks about the practice and common interest communities. Thank you.